question. So welcome, everyone. I'm Sarah Cleveland. I'm the faculty co-director of the Human Rights Institute here at Columbia Law School, one of the many co-sponsors of this event this evening. And I should caveat this by saying we know it's the beginning of exam period. We know there's a major student demonstration being held in Brooklyn this evening. But nevertheless, we were so tempted by the presence of Philippe Sands in our jurisdiction to give him a forum that we violated all our usual rules about not holding speakers at the end of the semester and begged and pleaded him to appear this evening, in addition to the keynote lecture that he's giving tomorrow as part of the conference on international arbitration and human rights that's being held here at the law school. So, as all of you I'm sure know, Philippe Sands is an internationally renowned barrister, scholar, practitioner of public international law, human rights, international criminal law, international environmental law. He is a professor of law at the University College London. He's also the director of their Center on International Courts and Tribunals. He frequently appears before the International Court of Justice, the International Tribunal on the Law of the Sea, in various international arbitration fora, and he's a widely accomplished writer in many media. So he has written a number of important past books, including the book Lawless World, Making and Breaking Global Rules, about, among other things, the debates in the U.S. and in the U.K. over compliance with international law in the period of the Iraq invasion in 2003, Torture Team, Deceptions, Cruelty, and the Compromise of Law, about the Bush administration torture team, and he has recently been working on a book project exploring the biographies of some of the great human rights and international law luminaries of the immediate post-war period, which has inspired, I think, to some extent, the talk for today, as well as a play that is now sold out in London and hopefully soon will be sold out in New York. So I will not give you any more teasers on that. I will let him talk about it to the extent he wants to. But he's a fantastic speaker, and it's really an incredible pleasure to have you here. So please join me in welcoming Philippe Sands.
Thank you very much, Sarah. It's really nice to be here. I did not need to be pulled kicking and screaming. I was very happy to come for the thing tomorrow, and I'm really thrilled to be here. It's an incredible law school with a wonderful faculty today, but also a very special law school in terms of its historical connection with these subjects. And indeed, as you will hear shortly, some of the material that I found in the archives at Columbia. So this is a particularly important place. Actually, I also didn't need to be pulled kicking and screaming, because I'm really here not to hear myself, but to generate questions and reaction from you. I'm not going to be intentionally provocative, but I'm going to invite you to think about the architecture of the modern system of international law and international criminal law in particular, by reference to two concepts. Genocide on the one hand, crimes against humanity on the other hand. They emerged at the same time. I'm going to talk a little bit about that. Genocide, in essence, is the crime under international law of intending to destroy in whole or in part a group. And it is distinct from crimes against humanity, which describes the systematic violations of the rights of individuals. They're two opposites, groups and individuals, and that's what I want you to have in your minds as I talk over the course of this evening, and as I very much invite you to intervene with your reactions. What I'm talking about has been the subject of a project that I've put probably more time into than any other project I've ever been involved in. It's lasted 5 years. It began with a personal invitation that I received in the spring of 2010 to deliver a public lecture in the Ukraine at a university in a city that was incredibly obscure to me. It is today called Lviv. It is on the western Ukraine. Is there anyone here from the Ukraine? Just out of interest. Does anyone know where Lviv is? Has anyone been to Lviv? Okay, so 2 or 3 people. It is a pretty obscure place. I was told when I arrived...
It was a center of Jewish culture before the war.
Yeah, I'm getting into that. That I was the first public international lawyer to visit the law school in 40 years. It's a city with an extraordinary past. It was called Lemberg under the Austro-Hungarian Empire until 1918. It then became Lwów, part of Poland, from 1918 to 1939. Then from 1939 to 1941, it became Lvov under the Soviets. From 41 to 44, it was Lemberg again under the Germans and the Nazis. And then from the summer of 44, it became Lviv as part of the Ukraine under Soviet domination until it became Lviv under an independent Ukraine in the early 1990s. So this is a city with a special past and a city with a very special university, older than Harvard, an incredible center of learning and scholarship in the fields of mathematics and science and philosophy, and, it has to be said, law. So I get this invitation to give a talk on my work on crimes against humanity and genocide, which is both my work in my classroom at University College London, in London, but also in the courtroom. I've done a lot of cases on crimes against humanity and genocide. The Pinochet case, currently the case for Croatia against Serbia, on genocide, other genocide cases at the International Court of Justice, on crimes against humanity, the case involving Muammar Gaddafi at the International Criminal Court. And so, in a sense, crimes against humanity and genocide are part of my everyday life. I wouldn't have accepted the invitation but for one personal factor, and it was that my grandfather was born in Lemberg in 1904, and I really wanted to go and see what it was like. Otherwise, to be very frank, I would not have taken the 3 flights it was necessary to take to get there, because there are no direct flights. So I accepted the invitation with great happiness, and actually agreed to go with my mother, my aunt, and my son, because it was like a return to an obscure place. And I spent the summer preparing for the lecture that I was going to give in October 2010 on crimes against humanity and genocide. And this is what I discovered. Let us begin with Herschel. Herschel is probably the greatest international lawyer of the 20th century. He was born in 1897 in a small town called Żółkiew, which is about 24 kilometers from Lemberg, Lviv. He moved to Lemberg in 1911, and he enrolled at the law faculty in 1915. He studied at the law faculty from 1915 to 1919. He took various courses. I now know what all those courses are because I've immersed myself into the archives of the city and found all of the students' course materials. Completely fantastic list of courses. Have any of you here taken a course on instinctivism versus primitivism? Have any of you taken a law course in a law school on hope and optimism? These are the kinds of things that they studied, as well as a lot of courses on the relationship between religion and law, and a lot of courses on criminal law. In 1919, he goes to Vienna, and he studies for his doctorate with Hans Kelsen, a name that many of you will be familiar with, and he gets a PhD which looks at the origins of the Permanent Court of International Justice. In 1923, he moves to London, where he accepts an appointment as a research assistant with a British international lawyer, Arnold McNair. Some of you will know McNair's famous book on the law of war and the book on the law of treaties. And in 1927, he gets an academic position at the London School of Economics. He then moves in 1937 he is elected to the Whewell Chair of International Law at Cambridge University. I'm going to paraphrase greatly, but the central theme that runs throughout Lauterpacht's work is that the individual is the fundamental unit of law. And this is reflected in all of his writings, in the books that he's written, the articles that he wrote, and the important work that he did, which I'm about to come to, in the 1940s. The war breaks out in 1939. In 1940, when the Germans occupy France and various other parts, and it's thought they may actually reach the United Kingdom, he sends his wife and his son, Ellie, who happens to have been my teacher of international law, to New York. And Ellie enrolls at Horace Mann a year after Jack Kerouac left. That was one of the things that Ellie told me. And Lauterpacht, the father, comes periodically through on lecture tours organized by the Carnegie Foundation. At some point, in 1941, he's introduced to Robert Jackson, who at that point is Attorney General of the United States. So he's a very well-connected individual by this point already. And Jackson uses him to come up with legal arguments to justify various actions that President Roosevelt wants to take to respond to the Germans, despite the United States' neutrality, in the face of opposition from most American international lawyers who just say, we stay out of this. In 1942, he's retained by the British to start thinking about war crimes. And in 1942, he also receives a commission from the American Jewish community to write a book on human rights, which he works on for 3.5 years and completes it in late 1944, and it is published in 1945 by Columbia University Press, and I'm very proud to have a first edition of that book. And that book sets out the first ever scholarly effort at a Bill of International Rights of Man. So it is the foundation stone for modern human rights. Leaves out many of the things many of the people in this room would care about, but it's an absolutely vital book. More significantly, in the summer of 1945, the book is published in June 1945, just after the United Nations is created, and in the summer of 1945, the new US president and the Soviets and the British and the French decide there's going to be an international criminal tribunal, international military tribunal for the most senior Nazi leaders. Those negotiations take place in London in July and August 1945. They are headed by Robert Jackson. They get into difficulty in the negotiations on a number of the crimes, including the crimes related to individuals outside of a pure conflict situation. Jackson drives up to Cambridge to have lunch with Lauterpacht and his wife at their house in number 6 Cranmer Road, and it is Lauterpacht who comes up with the notion of crimes against humanity. Firstly, he says, why don't you put titles into the book, into the statute? That will help with public understanding, it'll help with legitimacy. And secondly, you need to make individuals the centerpiece of the protection in relation to the third count and the fourth count, and why don't you therefore call it crimes against humanity? Jackson likes the idea of titles, likes the idea of crimes against humanity, which has been used before in a non-legally binding sense, but has never been used in a legal instrument. Takes the idea back to London, and the 4 powers incorporated. Point being that the origins of crimes against humanity in international law dates to the Nuremberg Tribunal and can be shown to have been the product of the intellectual thinking of Herschel. Origins, Lemberg. Of course, when I arrive in Lemberg and tell them all of this at the university, they have no idea that he was a member of their law faculty. They have no idea that the very subject they've asked me to address actually arises from their very own university. So that's the first thing I discovered. Wow, crimes against humanity has a sort of connection with Lemberg. So then I move to genocide. you will have jumped ahead and you will have worked out the amazing coincidence is that although Raphael Lemkin was not born in Lemberg, he was born about 300 kilometers to the northeast in a small hamlet, which is now in Belarus. In 1921, he arrived in Lemberg, which was then called Lvov, 2 years after Lauterpacht left, to study at the University of Lvov. And he stayed there from 1921 to 1926. I've identified all of their class materials, and I've been able to establish that they had exactly the same teachers of criminal law and international law. Indeed, it's not part of the thing I want to talk about today, but you can trace the origins of their thinking on criminal law to a single professor, Julius Makarewicz, a Polish professor, ultra-nationalist, Christian Democrat, professor who taught both of them criminal law. In the course of Lemkin's studies, a big trial takes place in Berlin that he becomes very interested in, concerning the killing by an Armenian of a Turk who was passing through Berlin. The Armenian considered, a man called Telierian, that this Turk was responsible for the killing of his entire family in the Turkish-Armenian conflict and killings of 1915, centenary of which will be celebrated next year. And this begins to get Lemkin thinking about these kinds of issues. He leaves the university in 1926. He goes to Warsaw. He becomes a public prosecutor. And in 1933, having attended various League of Nations conferences, he comes up with the idea, partly lifted from another academic, a Romanian called Vivi Pella, of two new crimes, barbarity and vandalism. Barbarity and vandalism are not intended to protect individuals. He's gone a different route. They're intended to protect groups. Timing is not good. Conference in Madrid, October 1933. Hitler has taken power. Not exactly the best moment to be talking about protection of minorities, the protection of Jews, the protection of anyone who is a group in a particular community facing difficulty. He's thrown off the Polish delegation in 1933, and he goes into private practice. In 1939, he is in Warsaw when the war breaks out. He escapes. He goes to see his parents in Volkowisk. He makes his way to Stockholm, and there, within 4 months, he has learnt Swedish completely fluently enough to be able to accept a one-year teaching position at the University of Stockholm, where he teaches a course on commercial transactions. But on the side, Lemkin decides to start collecting all the decrees he can find of the Nazi-occupied territories. He does it with the help of a corporation that had a Swedish corporation that had previously retained his services when he was a lawyer in private practice. And he gathers literally thousands and thousands of pages of decrees. Some of them are in the archives of this university, so it's a very exciting place to go and have a look, and I found a lot of stuff here. In 1941, he receives an invitation from the law faculty at Duke University, and so he takes the long route from Stockholm to Duke. Western Europe is closed, the Atlantic route is closed, so he takes a trip from Stockholm to Riga, to Moscow, to Vladivostok, to Kyoto, to Seattle, to Chicago, and finally to Durham, North Carolina, with virtually no money and no possessions, but 6 valises full of Nazi decrees. You know, you can just imagine this guy schlapping this stuff literally all the way around the world. At Durham, he spends 2 years analyzing the decrees. He's then retained by the War Department to provide advice. And in May 1945, he manages somehow to persuade Jackson to sort of take him onto his team. He's a difficult individual, that's an understatement. He's a sort of loose cannon, absolutely obsessive about these subjects, really knows his stuff, and totally obsessed with the subject I'm about to mention, which is the book that he writes on commission from the Carnegie Foundation, which is called Axis Rule, which is published in November 1944, and which is concerned not with the protection of individuals, but with the protection of groups. Chapter 9 of Axis Rule is entitled Genocide. And that is the first time that word is used in print, and he is the inventor of the word. He's then retained by the Jackson team for a few months, but he's a loose cannon, constantly going off to talk to people at the New York Times, talking to the press, difficult individual, and is devastated when the Nuremberg Statute, agreed in London on the 6th of August, has no reference to genocide in it. Only crimes against humanity, war crimes were limited to those, a couple of others, but genocide is not mentioned. Flies to London, makes a thorough nuisance of himself. The British are completely against the concept of genocide because the concept of genocide will be used by those under colonial oppression to bring claims against the United Kingdom. And frankly, the Americans are not really much more enthusiastic about it. In particular, Jackson, under real pressure from Southern senators, that problems with African Americans in relation to past practices in relation to their communities. Somehow he manages to persuade the Americans to go with it over the British objection, and he sneaks genocide into the indictment, taking his definition, the intention to destroy groups in whole or in part. So by the time the trial starts, on November the 20th, 1945, crimes against humanity and genocide are both part of the proceedings. So just pause there for a moment. When I got the invitation from Lviv, I had no idea that the subject that I was talking about was so intimately connected to the very university I was going to. And that, I thought, was remarkable. What happened in Lviv in that period that caused two individuals to come up with different ways of thinking about how international law could be utilized to prevent mass atrocity. One focusing on the individual, the other focusing on the group. In 1946, Lauterpacht writes a book review in the Cambridge Law Journal on Lemkin's book. It's sort of damning it with faint praise, never actually mentions the author. Essentially, Lauterpacht thinks that Lemkin is not a true scholar. He's a collector, a gatherer, and is entitled to credit for having been an excellent gatherer, but nothing else. But Lauterpacht has another problem with genocide, and here we get to what I want to explore with you in conversation, and that is this. Lauterpacht believes that the concept of genocide will undermine the protection of individuals. It will replace the tyranny of the state with the tyranny of groups. And Lauterpacht fights tooth and nail to stop genocide making its way into the indictment and making its way properly into the trial. Genocide is used on the first 2 days of the trial, and it is not then used for 6 months. It disappears out of the trial. It makes a reappearance through one of the British prosecutors, David Maxwell Fyfe, the drafter of the European Convention on Human Rights, who is buttonholed by the correspondent of the London Times newspaper. I mean, the simple point is things have not changed. The interplay between individuals, the media, governments was exactly the same in those days. Lemkin got to Maxwell Fyfe through Mr. R.W. Cooper, the correspondent of the London Times, who he covered every day of the trial at Nuremberg and wrote a fantastic little book about the trial, one of the best books I think that's been written on it. It was published in 1946. Interestingly, before Cooper was the correspondent in Berlin and Nuremberg, he was the lawn tennis correspondent of the Times of London, a fact that I've always really found rather endearing. But he wrote a great book, and Cooper was close to David Maxwell Fyfe, who was the deputy British prosecutor. The main British prosecutor was Hartley Shawcross, Sir Hartley Shawcross, the British Attorney General. And somehow Lemkin persuades Cooper to persuade Maxwell Fyfe in the cross-examination of von Neurath, who had been foreign minister for a brief period to raise the genocide issue again, and it takes on a new life. So by the end of the trial, in August and September 1946, 3 of the 4 Allied powers are calling for convictions for genocide: the French, the Soviets, and the British. Robert Jackson never once uses the word genocide. He is opposed to it, and it is plain that he has been leaned on essentially by Southern senators. That constituency has prevented him from doing it. The judgment is handed down on the 30th of October and the 1st of November 1946. Plenty of convictions for crimes against humanity, but nothing on genocide. The word is not mentioned once in the judgment. Even more galling for Lemkin, there's not even a summary of the arguments of the parties. It is nowhere to be found in the judgment. So a very sharp slap across the face. He's devastated. He describes later to an American prosecutor that that day was the darkest day of his life. What happened subsequently? Within 3 months, the UN General Assembly had affirmed in resolutions 95 and 96 that crimes against humanity was part of international law and genocide was part of international law. They basically overruled the Nuremberg Tribunal. And 2 years later, it is known, the first modern human rights convention is adopted, Convention on the Prevention and Punishment of Genocide, Lemkin's convention. Lemkin has shepherded it through, and he has been the one who has really driven it. The day after the Genocide Convention is adopted at the United Nations General Assembly, the Universal Declaration on the Protection of Individuals and Individual Human Rights is adopted, non-binding. There is no convention on crimes against humanity, no freestanding convention on crimes against humanity. Although right now, Sean Murphy, graduate of Columbia Law School, is the rapporteur for the International Law Commission, looking at what needs to be done on crimes against humanity, international law, and I'm having a lot of contact with Sean on that issue. So what happens next? Well, for 50 years, both concepts sort of basically disappear. Nothing much happens until the collapse of Yugoslavia and Rwanda. And those 2 events caused the Security Council to create 2 freestanding international criminal tribunals, both of which have jurisdiction over crimes against humanity and genocide. And crimes against humanity and genocide come back into the frame. That was nearly 20 years ago, and they have now had a significant life. And it's to that I now want to turn, just in the remaining few minutes that I want to speak, and then throw it open. So, one question to think about is, have these international legal norms, crimes against humanity and genocide, made the blindest bit of difference? Can we actually demonstrate that one rather than the other, or both, has actually affected any human behavior? That's a big question. I can't possibly answer that question. But it's obviously a central question that we need to think about. And in relation to that question, we also need to ask ourselves, what about the relationship between crimes against humanity and genocide? Why do we need to have a norm of international criminal law that is aimed at criminalizing the destruction of a very large number of individuals, on the one hand, and destroying groups on the other hand? It's worthwhile spending a moment about what is the essential difference between the two. From a practice, now I'm speaking as a practicing lawyer arguing these types of cases. Essentially, the difference is very, very simple. If 100,000 individuals are killed unlawfully as part of a systematic extermination, that's going to be a crime against humanity. Simple as that. You don't need to show anything beyond the fact that there was a systematic act of killing of a large number of individuals that was unlawful. If you want to prove that the killing of those 100,000 individuals was an act of genocide, you have to do something else. You have to prove that the individuals involved in the killing killed as part of an intention to destroy in whole or in part a group. That is actually a very difficult thing to do, because states and armies and individuals generally don't type out or write out on pieces of paper that they're engaging in the act of killing with a view to destroying a group. The Germans sort of did it, but very few others have done it. And that means that you're left to deal with it by inference. And that is an extremely problematic exercise, as we've learned, particularly in relation to the Yugoslav conflict. So the two crimes have existed side by side. And I've become increasingly troubled about the fact that there are two crimes in this way. Why? Firstly, one of the things that has happened in the last 20 years in particular is that genocide has emerged as what some people have called the crime of crimes. The threshold has been set very high, although actually, interestingly, there's a recent ICTY first instance judgment which characterized the killing of just 3 individuals, in the case of Tolimir, as genocide. That's a very rare judgment. I don't know whether that will withstand appeal. That's on appeal. But it's an attempt, I suspect, to lower the threshold, to lower the bar. But I've become increasingly concerned that the hierarchy that has been created has led to a very unfortunate situation. And it is this. Prosecutors at the ICTY, at the ICTR, and at the International Criminal Court, and some have written about this, come under intense pressure to indict for genocide rather than crimes against humanity. Why? Because, against the background of an emerging hierarchy of crimes, for many communities and for many victims, the idea that those who have been engaged in acts of killing on that scale might only be seen as a crime against humanity is seen as letting them off the hook. For example, in 2007, when the International Court of Justice gave its judgment in the case brought by Bosnia and Herzegovina against Serbia, and the court ruled that the Serbian state was not itself responsible for committing genocide, although it had failed in preventing others to commit genocide. The headlines in the government run newspapers the next day, the Belgrade Courier, for example, "We are innocent." Being found responsible for crimes against humanity is seen to be a couple of notches down, not significant, you are off the hook. And ironically, having spent a lot of time in that region, in Bosnia and Serbia and in Croatia, the fact that the ICTY brought indictments for genocide in Bosnia, but not in Croatia, has caused a real tension between Bosnian communities and Croatian communities. It's an unintended consequence of the hierarchy of crimes that has been created. So that appears to be a problem. The existence of the two crimes in parallel tends to skew the exercise of discretion by prosecutors at these international tribunals. And I think that has consequences which we have not fully thought through. But that's not the only problem with the existence of the two crimes separately. There is a greater problem, and this is a problem that has not so much been written about, but which I've observed from my own cases. I am concerned that the concept of genocide tends to reinforce the sense of group identity. We're here not into a sort of utilitarian legal analysis, but into a psycho-legal analysis, looking at the psychological implications of a crime that is concerned with showing intention to destroy a group. I've done a number of genocide cases, and I have observed that when you are with senior government officials, and I'm talking about prime ministers, foreign ministers, presidents, and they spend a day with you watching videos about the terrible things that have been done to their community, and then you as the lawyer say to them, well, that's really terrible. But actually, we need to be able to prove for genocide that those acts took place with the intention to destroy that group in whole or in part. Where's the evidence to show that? People get pretty upset. And they not only get upset, but they get upset in the context of an observed reinforcement of the them and us situation. They did that to us. In other words, the exercise of going through the prosecution of a genocide case requires you to focus on groups and to reinforce group identity as the heart of the crime. And that, from my perception, raises problems in terms of reinforcing the very thing that it seeks to address, namely the propensity of one group to do terrible things to another group. And that was Lemkin's point in response to Lauterpacht, although very interestingly, the two men apparently never met, which seems remarkable. But Lemkin's response to the critique of Lauterpacht that one should only focus on individuals and the protection of individuals is, yes, well, that may be right in an idealized world, but the reality is that people do not get killed because of their inherent individual qualities. They get killed because they're a member of a group. And the law must reflect that reality. A law that does not take into account that individuals are murdered on a large scale because of group identity, national, racial, ethnic, religious, whatever it may be, cannot be a law that works. So I can see that argument, and I can see Lauterpacht's argument, and I said to Sarah beforehand, I'm struggling to work out which of the two arguments I find more persuasive, which is why I'm going around talking about it with various groups of intelligent people to get a sense of what reactions are. Now, this issue is not a new issue, and let me end with one of the documents that I found here in Colombia that had a profound effect on my thinking about these issues. There is a wonderful archive here. And the archive here contains material that is very pertinent to this issue. It's just worth spending a moment on the reactions to Lemkin's book when it came out. It got very high-profile reviews. The first review was in the Washington Post on the 3rd of December 1944, and 2 weeks later, the New York Times Book Review gave it the entire front page. It was reviewed by a man called Otto Tolicius, who had won the Pulitzer Prize for the newspaper as a journalist. He'd been the newspaper's Berlin correspondent, so he really knew what he was talking about. He described it as a most valuable guide. This is Lemkin's book that I'm talking about, and bemoaned the fact that its dry legalism would mean that it would only have a very small audience. But he had other more serious concerns. He strongly objected to Lemkin's anti-German tirade, and in particular the view expressed by Lemkin that the terrible acts that he described reflected what Lemkin called the innate viciousness of the German racial character. In other words, Lemkin had fallen into the very same trap that he was seeking to prevent: the taking of group identity in the prosecution of individuals. Tolicius was equally irritated by Lemkin's errors that he considered him to have made, and in particular the assertion that the vast majority of German people put Hitler into power through free elections. So the first review that appeared of that kind, praiseworthy, but also a pretty powerful critique and a hint of what was to come. It came not in the form of a published review. The most powerful critique, I think, of Lemkin's work and of the idea of genocide, and the one that I have not been able to get out of my mind since I first read it here at Columbia, is a very private letter that was sent to Lemkin in early 1945 by a rather remarkable Austrian immigrant and also an acquaintance of Lemkin's, a man called Leopold Kohr. Has anyone heard of Leopold Kohr? It's very interesting. Leopold Kohr was an extremely interesting individual and scholar. His most famous pupil was E.F. Schumacher, and it was in fact Kohr, not Schumacher, who coined the notion of small is beautiful. You'll see why that connects to what I'm about to say. He wrote to his colleague Lemkin that Axis control was extremely valuable, but also extremely dangerous. I do not delight in attacking friends, Kohr wrote, so I will keep this review private. It is for you only. You've made selective use of the facts, and you should have attacked not the Germans, but the Nazis. Dr. Lemkin does not mention National Socialism once, Kohr wrote, which was only almost accurate. Chapter 9 on genocide makes one passing reference to National Socialism. But Kohr had a more serious complaint. He thought the book felt like political journalism, not scholarship, and that Lemkin had taken facts that confirmed preconceptions and presented only a partial account. Kohr referred to this as a Prussian method of writing history, i.e., even Kohr falls into the trap of groupthink. We all do it. I mean, it's really quite remarkable. But then comes his strongest criticism, and this really is the heart of the issue for me on thinking about the utility and consequence of genocide as a legal concept, taking the destruction of groups rather than individuals at the heart of your thinking. His strongest criticism in the private letter to Lemkin was in relation to the chapter on genocide. The most interesting, he wrote, but also flawed. By making groups the prime beneficiary of international law, Lemkin had fallen into the trap of adopting a conception of genocide that followed exactly the same biological thinking that gave rise to anti-Semitism and anti-Germanism. And the criticism reaches at this point, at the end of the letter, its most acute focus. He says to Lemkin, you should have adopted an approach that made the individual, not the group, the object of prime concern. Interestingly, Kohr had no idea that in parallel with Lemkin's work, Lauterpacht was working on the protection of the individuals. I found nothing to indicate that Kohr was aware of Lauterpacht's parallel work. By emphasizing groups, Kohr wrote, you have taken a road which, even if it does not always end in Hitler, leads to Hitler. That is a really powerful and stinging critique. But the heart of it, and I've not been able to shake it off, is that by taking the protection of groups as the centerpiece of the legal concept of genocide as a crime, you do the very thing that you seek to address. You reinforce the notion of group identity, and you contribute to a context in which the feelings of one group, in particular, as I have observed, of irritation that the concept of genocide has not flown in certain cases, creates a real problem. To close, we see this right now. A hierarchy has been created. Think about what's happening to the Christian community in Mosul right now. The terrible, terrible crimes that are being committed against groups over there. People don't really pay a lot of attention to it until President Obama uses the G word. And at that point, all hell breaks loose. It was astonishing. I mean, you may have found it in your times or in some of the work that you were involved in, Sarah. I had various foreign ministries from around the world saying, why did Obama do that? Getting in touch and saying, why did Obama do that? We've now got our parliaments on our backs, telling us we've got to do something, telling us that we need to take steps to prevent this. The acts hadn't changed. Whether you call them crimes against humanity or genocide, they are the same heinous, terrible acts. And so the fear, to conclude, that one is left with is that the existence of the two crimes in parallel and the emergence of a hierarchy between them has led to a situation in which the media, certainly, but public opinion more generally, possibly, pays considerable attention to heinous acts when they are characterized as genocide. But if they are only characterized as war crimes or crimes against humanity, then they have a lesser scope and a lesser resonance, and somehow they are okay. We are innocent, the Belgrade Courier put it, because it's only war crimes, it's only crimes against humanity, it's not genocide. And so I end with a question. Has the concept of genocide actually done more harm than good? And do we actually need it? I don't have an answer to that question, but I think it's something that we need all to reflect on a lot more than we do. Let me stop there and throw it open for any comments or any questions.
So, Philippe, that was fantastic, and I'm sure it will provoke many reactions. I would just offer two that I'd love your thoughts on. One is with respect to hierarchy of crimes. We see somewhat similar problems in another area you've worked in, which is torture and cruel, inhuman, and degrading treatment and punishment, right? And, much of the Bush administration memos were to try to push conduct into the second box out of the first one. We have a convention, as with genocide, that provides for detailed criminal responsibility with respect to torture. No similar convention outside of the wartime context for CIDT. And so I wonder if this is something sort of inherent in if you see this tension as inherent in genocide or peculiar to genocide and crimes against humanity, or if you see resonances also in the torture CIDT area. And then second, with respect to groups versus individual, I'm listening to you and I'm struck by the fact that the concept of persecution in refugee law and under crimes against humanity also privileges conduct that is directed against individuals for reasons that could be considered group identity related, right? Religion, political affiliation, race, so on and so forth. And yet they do not seem to have created a similar privileging of, sort of group identity, or maybe they do. And I wonder if is the problem with genocide that it is, it is defined as the destruction of a group, and would we avoid the whole problem simply by redefining it as going after individuals for these kinds of reasons?
Yeah, well, they're really big and complex questions. So on the first, on the hierarchy, it's very interesting, and you're absolutely right. Of course, we also have the same in the domestic context, murder versus manslaughter. But of course, maybe not. Well, I'll
Crimes versus civil war.
Well, and then I'll come on to the hate crime issue, because of course the issue is then I'm asked, so are you against hate crimes? And of course the answer is, of course I'm not against hate crimes. Of course, when a hate crime is perpetrated, it has a particular quality that distinguishes it from someone just being beaten up in the street because they happen to be a passerby and someone feels like beating them up, rather than the targeting of that person because of their inherent characteristics or qualities. So let me take your first question. Interestingly, when we go back to the distinction between torture and cruel, inhuman, and degrading treatment, they weren't as articulated at the same level. There's a single convention that deals with them, and the convention creates explicitly a hierarchy. I think that's a difference between crimes against humanity and genocide, because I think the original conception was that they were at the same level. That has changed subsequently. But interestingly, And interestingly, this week, as you will know, the Bush administration had focused, or let me put it a different way, some lawyers associated with the Bush administration had focused on a judgment given by the European Court of Human Rights in the early 1970s in relation to the British practice of hooding IRA prisoners in Northern Ireland, and ruled that this was not torture, it was cruel, inhuman, and degrading treatment. Well, guess what? That has rankled for more than 45 years. And guess what? Yesterday, the Irish government announced that it was going to go back to the European Court of Human Rights and ask them to reopen that 1971 judgment on the basis of what we have learned subsequently in terms of the psychological consequences of hooding. I query whether the court has a jurisdiction to do that. I think it's a complex thing to do. I mention it only to illustrate the point that these kinds of decisions and judgments taken many, many years ago produce consequences that are very long-lasting and produce feelings, in Ireland in particular, of being hard done by that have lasted 4.5 decades. So, yes, there are different hierarchies. Those hierarchies continue to produce consequences over time. And those who design these laws need to think about that in the design of the laws. Of course, as I've described to you here, one can hardly describe the process that happened in 1945 and 1946 as an act of conscious design. Crimes against humanity and genocide emerged by accident. Basically, a couple of individuals who happened to be in a particular place at a particular time snuck these concepts into various documents, and they took on a life of their own. So it isn't a case of a legislature sitting and having an informed, rational debate. Oh, we could go this way, or we could go that way. What's the best way to go? In relation to your to your second question, I really am stuck on this: the privileging of individuals against the privileging of groups. I have a lot of debate at home around the kitchen table with my wife and my kids about this. If I get attacked, my wife says, "Well, so are you against hate crimes? Are you against, gender-based crimes? Are you against, And I, of course, can't say, no, they should be done away with. We should just have the crime of bashing people up. No, life isn't like that. We know that motive plays a role. So I need to think more about the implication of privileging the individual versus the group in the domestic context as compared with the international context, something which I'm very ill-equipped to do because I don't have the background in the domestic context. It is plain to me, though, that Lauterpacht has been shown to be right in terms of the fears that he articulated, that built into the concept of genocide and the concept of crimes against humanity, a development has occurred which has created a hierarchy and which has tended to privilege the protection of groups. Whether that undermines the protection of individuals, I don't know, but the suspicion must be that it does, for the simple reason that if something doesn't reach the threshold of genocide, the media doesn't pay as much attention to it. States don't feel quite so compelled to do something about it. We think less about it. And the other consequences is that the communities who've not had their level of victimhood characterized as a genocide feel pretty pissed off about it. You only need to look at what's happening still today in relations between Armenia and Turkey 100 years later. And you sort of have to ask yourself, why does it matter whether what happened in Armenia in 1915 is or is not characterized as a genocide? A terrible act of mass killing happened. That is established. And the reality is that if it's not characterized as a genocide, it seems to be less important, less terrible, less significant. And you see this creeping in other ways. I noticed that there were some individuals who were characterizing the summer attacks on Gaza as genocidal. And the moment that happens, attention ratchets up and everyone becomes engaged. And what is it about that concept that gets people so much more agitated? And what is it about that concept that then leaves crimes against humanity and war crimes, which are equally terrible as genocide, floundering as somehow a reflection of innocence?
Don't you need genocide as a trigger for international action? I mean, if there are crimes against humanity taking place all over the world, don't you need, like, that was part of the debate about getting involved in Yugoslavia, was it genocide? And I remember coming here to a conference in the 90s, and they kept saying, well, is it genocide?
Well, one argument, and you're better placed than I am, was the interpretation of the Genocide Convention that because there was an obligation to prevent genocide, every state that was a party to the Genocide Convention, the moment something called a genocide was happening, had to intervene or do something. And because there isn't an equivalent obligation to prevent crimes against humanity, there's no equivalent need. I'd say I don't personally buy that interpretation of the Genocide Convention. I don't think that because a genocide is happening, as opposed to crimes against humanity, there's a greater obligation on states in the international community to act. So,
it certainly seems sort of perverse, arguing about, like, does it rise to the level of genocide?
Well, it's perverse in that it makes it more likely, if you want to look at it on policy grounds, it makes it more likely that the acts of killing will limit themselves to crimes against humanity to avoid some sort of reaction or intervention from the international community, which is sort of crazy.
Just looking at this about the Srebrenica, I mean, that's sort of what triggered our involvement in Yugoslavia, right? For us to ratchet it up.
No, it started. I mean, international involvement started long before Srebrenica.
It started before, but then there was a sense that they had really gone too far.
I think they're completely different. I think the simple point is I don't draw a distinction between crimes against humanity, war crimes, and genocide in terms of the reaction and rights of the international community. There is no more of an obligation, I think, in law or in policy to prevent and to stop mass atrocity, whether it's characterized as one or the other. There's a gentleman over here, and then I think a lady over here, and then at the back.
That was an excellent presentation. I spent a lot of time in Cambodia with Documentation Center of Cambodia, and I think that the Khmer Rouge genocide is probably the paradigmatic case of what you're talking about. And you have this very hard circumstance in which you have a massive crime, probably one of the most monstrous in the world, which doesn't quite fit the legal definition of genocide, almost deliberately, right? Because Stalin wasn't one of the people crafting the Genocide Convention, and deliberately excluding political groups in class. And you have this case where the prosecutors are trying to focus on Buddhist monks or Chan Muslims or finding some minority groups, which then contributes to divisions within Cambodian society, right? In which some victims are considered kind of more important than other victims.
Absolutely.
And it's definitely very hard for average Cambodians to understand why it might not be a genocide and what this means. And I think it's really causing actual psychological problems over there. So I just wanted to make that comment. But then as a question, I completely agree with you. So what is to be done? What people who buy your case that crimes against humanity should be elevated, or genocide should be broadened, or somehow whatever. I mean, what can we do? What actions can we take?
Okay, so I'll come to that question first. But can I just say, because it's the other part of the privileging, not only privileging groups versus individuals, but privileging some groups. So you deprivilege, if that's the right word, or disprivilege, or I don't know, whatever the word is. If you're not within that category of groups, it's fine to sort of exterminate them. So if it's political, if it's gay, or if it's just not in the list that's in the convention, it's fine. It's not genocide. It might be something else, but it's not genocide. I think that's really problematic. Incidentally, the other thing that I'm struggling with as I conduct this research is that the only group that Lemkin never wrote about in any of his work, and the persecution of homosexuals was very well known and very widespread, was what were then called homosexuals. And the slightly complex issue that I'm grappling with is what consequences I should draw from that very obvious and apparent failure in relation to a man who himself was never married, had no children, in fact, had no, as far as I can tell, and I've been through every archive that exists, had no amorous encounter of any sort that has ever been recorded, apart from when he was 17 years old. He writes in his previously unpublished memoir, which happily Yale University Press has not put out, I went for a walk on a hill with a girl in a brown dress, and she tried to kiss me, and a strange feeling came over me. That's it. That is the full extent of Raphael Lemkin's amorous, intimate life. That's all we know about it. So what does one say about that? Does one conclude that perhaps in a psychological sense his focus on the groups was that he may have been himself a member of a group, which at that period one did not write about and talk about, and this was his... I don't know. These things are very, very complex as to what is going. So what is to be done about it? Well, I think there are two options. Actually, there are more than two. There are probably 25 options, but here are two options. One option I sort of used in oral arguments at the International Court of Justice in April this year in the case brought by Croatia against Serbia, where on the Croatian side, and here again is the other problem, because there's a convention on genocide but no convention on crimes against humanity or war crimes, when acts of atrocity happen and one state wants to go against another state, they have to shoehorn themselves into whatever convention there is. So the only convention there is a genocide convention. So Croatia files a genocide claim against Serbia in 1999 and has to somehow shoehorn these terrible acts of killing into a genocide crime and then spend 15 years driving themselves crazy trying to prove that it is a genocide, when in fact it would have been much easier to prove something else, but there's no convention that allows you to do it. Has a very significant consequence. The Bosnia judgment sets the threshold very, very high, the ICJ judgment of 2007. I think, and here I speak personally as an academic, not as a practitioner, personal just for the camera, in case any of the judges are seeing this, it's a terrible judgment. It's an absolutely shocking judgment in terms of its analysis and in terms of the logic that it applies. And it is plainly, on my reading, motivated by political considerations. They did not want to be a court which ruled that an entire state was responsible for an act of genocide. They wanted to avoid that, and so they construct something. That's had all sorts of unintended consequences, but of course it makes it very difficult for Croatia to then prove that a threshold has been reached, but we argued before the court, lower the threshold. In a sense, normalize genocide. Why does it have to be the killing of 10,000 people or 100,000 people? Why can't it be two people who are part of a community? The Ptolemy case. So one option is to lower the threshold for genocide. Another option is just to get rid of the crime of genocide completely. And it's obviously not going to happen because of the way the international legal processes work. It's there. Getting rid of treaties is very, very difficult. Third way, which is why I'm very supportive of Sean Murphy's efforts at the International Law Commission. I don't know what he'll end up doing, but it focuses on crimes against humanity, is to have a convention on crimes against humanity, which allows that legal term to grow in a way that it has not grown. I don't know which of those three or permutations thereof I would go for. What I do know is there is a problem, and we can't just bury our head in the sand and hope that it will go away, because I think these problems will tend to become more entrenched and the difficulties will become heavier. So I think we need to start thinking about these issues. I think there is thinking about it going on at the International Criminal Court in the prosecutor's office, but they tell me they come under intense pressure to indict for genocide. And look what happened in Sudan. Was it actually, in the scheme of things, a socially useful thing to do to indict President Bashir for genocide rather than crimes against humanity? It had the effect of galvanizing a huge amount of attention, which is probably what partly motivated it. but was it a socially useful thing to do in the scheme of things? You had a question, and then Stephen.
Well, I was curious, talking about tipping points for action or at least government engagement. I'm curious about your thoughts on the responsibility to protect, and if you think if an asset becomes more entrenched, you can help them equalize this dichotomy or balance the hierarchy so that at least the actions that states might take would be the same regardless of if it's genocide or crimes against humanity.
Well, I'm very glad you've raised that because I think that's a very central part of the response to the previous question. I'm personally very, very in favour of the work that is being done on responsibility to protect, and in part because of the formulation that it uses, which, as currently crafted, does not home in on the nature of the atrocity that is being committed. But my fear is that as it develops and as it gains in currency, which it will, and as it should, part of the trade-off that will come in due course will end up focusing precisely on this issue. There will be opponents, and in a political negotiation, proponents may think that they can buy off some of the opposition by limiting the circumstances or areas in which an emergent norm is triggered. And I think it would be nothing short of catastrophic to have a responsibility to protect emerge, which is limited to just, let us say, one situation, a situation that is known as genocide. I think that would be extremely problematic. But I fear, in the real world of politics and states and the UN, that is a danger about what will happen. And that has to be resisted. I would say it would be better to have nothing than a responsibility to protect that is limited to the crime of genocide. Because that would tend to reinforce that focus and send out a signal that anything that isn't a genocide doesn't rise to the threshold of requiring or allowing intervention. And I think that would be really, really problematic. Yeah.
Good question. Thank you for your remarks. First of all, on the tone of your case, I think many states, and maybe Sarah would correct me, including the U.S., in their understanding in the ratification of the Genocide Convention, require a certain scale level. And if many states do that, is that the official interpretation then of the convention, or can the judges brush that aside and interpret it as they see fit? Because the wording says, makes no distinction with regard to notification.
I've thought
got that understanding. Will that govern this case?
I've thought a lot about that question in the preparation of the hearings earlier this year, and in the book that I wrote. I mean, we went all the way back, just on the case, and you can read it in the pleadings. They're all public. They're all online, and the oral arguments, the issue really crystallized. We went back to Lemkin's work, to the work of Ben Whittaker in the 1980s on the minority rights issue of various UN special rapporteurs. And there never was a high threshold built in on those writings and those interpretations of what the convention actually said. We could spend 14 hours here on the legal effect of understandings entered in by a single state, or 3 states, or 140 states, or all states, in terms of interpretation of what it means. I think you'd need to go through and look at the totality of the understandings that are put in. It's a convention that does not allow reservations. And so the default position of a court that's interpreting those understandings is against that background. They're going to have a limited currency in terms of the legal consequences that they galvanize in an international court context. But I think the reality is that the way any judge functions is she or he will take account of a series of understandings in where they're going to set the threshold. And I suspect if you talk to a lot of the ICJ judges in the majority in the Bosnia-Serbia case, I think they will probably tell you privately, but not publicly, they would have been influenced by those kinds of understandings. But they don't articulate it in the judgment, and I think they can't articulate it in the judgment. So I think it does have a consequence. The law is not something that is applied mechanically. I mean, for those of you who are students here, one of the things that certainly I was never taught, I'm sure it's very different at Columbia today, is the law is not something that is mechanically applied. Oh, fact, crime of genocide, put the two together, it does or doesn't amount to genocide. There's a huge amount of wiggle room in which the intervention of the individual adjudicator or a group of adjudicators working collectively or not pushes things in particular directions. We all know that now. I wasn't taught that. It came to me as a surprise later on, but I suspect the answer is it will have a consequence. All the way at the back.
Thank you for your talk. I want to just discuss the issue of whether genocide entrenches identities. And I see parallels to the United States domestic politics and this idea of colorblindness. And, it would be better if we focus less on ethnicity and just more on our shared identity. And I believe that. So if you look at a lot of the situations, like you acknowledged, they were committed with some of these group considerations in mind. And so then the erasure of the group consideration when it comes to the remedy is almost a secondary violence or a psychological violence against these groups again. And it's also removing a layer of analysis. So if you're thinking about prevention, if we're thinking about how to adequately remedy the situation, if we just say that it was unlawful actions towards a group, but not or unlawful actions towards individuals, but not taking that group analysis into focus, then you lose a level of analysis. And then also, there are scholars in the field of intersectionality who even say that there's power in particularity. So maybe even beyond the analysis of what these like groups, we can look at an intersectional focus of how does gender interact with ethnicity, interact with religion, interact with this, and give us another level of analysis so that we can also better remedy the situation. So I think, I guess my humble suggestion, just being a law student, for going forward is that it'd be really interesting if you look also at domestic scholars looking at these issues like Kimberly Crenshaw, Christy Dodson, and also talk to get as many perspectives of victims as you can and see, because in some situations in the domestic U.S. context, I think a lot of African Americans do not want that group identity to be erased, but in other contexts, others would. So it'd be interesting to get that perspective.
I'm really grateful for that intervention. I mean, I already mentioned, I think, I feel unable to engage fully in what I've stumbled across from my arcane world of international law because I'm not equipped to look, or I have not so far looked, at the domestic analogies. And I think I've signaled that when I've come back to the issue of hate crimes because I've realized, and I've done some of the reading on that now. But taking the point that you're making, I mean, at the heart of what you've just said is a really fundamental question. And the reason that when one talks about these things, people ask a lot of questions, and it really gets people thinking, who are we? What am I? Who are you? Are you you? Are you a member of a group? Are you a member of many groups? We're all members of many groups. There are lots of ways of identifying ourselves. There are lots of ways of defining ourselves. How should the law, or not, take into account that sense of identity? Coming back to the question that was put earlier, what would I do about it? So I've tried to imagine a scenario where the crime of genocide just disappears. Okay? Would I imagine that racial or gender or sexual orientation or national or ethnic identification should therefore be excluded altogether from the prosecution of an international crime of mass killing? No, I don't. think it should, of course, it should not be completely excluded. And so, having concluded that, one asks oneself the question, well, how then could it be taken into account in a way that signals the international community's desire to stop certain types of behavior, to penalize and to prevent, whatever the reasons for the international criminal order are, and they are manifold. And I've wondered whether, if one imagined a scenario in which the word genocide was wiped from the statute, and you were left just with crimes against humanity, I suspect what international judges would do is that they would find ways of carving out a sort of crime against humanity plus, or dealing with it as part of a sentencing issue, so that the sentence in relation to a racially motivated or an ethnically motivated or a nationality motivated act of killing would be punished in a different way. Or one can think of other factors in relation to the manner in which it was prosecuted, the manner in which it was proven. There are lots of different ways. But coming back to the point, the principal point you make, which I think I've understood it as this, is tinkering around with issues of identity in the definition and prosecution of crimes domestically and internationally is a really complex issue. And I really understand that. And I'm struggling to work out how to respond to it. But I think you've understood your question, that what I'm principally trying to do is get a debate going where there has been no debate. What is astonishing in the world of international law is no one asks themselves the question, is the Genocide Convention a useful thing to have put on the international statute books? When I first looked at it, it's there, it must be a good thing, mass killing happens, so great. And it's taken me 25 years of working in this field, astonishing, it's a reflection on me rather than the field probably, to start asking that question. Perhaps there is a problem with it, and perhaps we need to find ways to address that problem. So I very much appreciate that the way your question has gone.
So we probably have time for one more question.
Should we just get this lady? Oh, sorry. You'll have to tell me you'll have to help me because.
Well, Doug had his hand up for a very long time.
Okay, I'm sorry.
Have you withdrawn your hand, Doug?
Sorry. Did you? Let's have two then. Let's have two.
Okay.
One of the
And then I'm so sorry.
one of the main differences I perceive between domestic and international law, and I've been practicing law for the past 20 years, domestically and some international advocacy issues, is that domestic law tries to perceive norms. How do we want our society to be? One of the main issues is, I don't want my society to be racist. I don't want individuals in my society to be racist. As opposed to international law, which is, of course, politically motivated, and I do not perceive it as something ideal. Within that boundary, dealing with war crimes, crimes against humanity, and so on, most, if not all, of these actions are politically motivated. And as such, this is where I see the problem. Now, regardless, this is why I see it not so relevant if you're always acting against a group.
So you're taking Lemkin's position.
Yeah, I do not. Once it's politically motivated, a group, an armed group, an institution, a state, uses its force to kill people. When that is politically motivated, I think that's enough. And I don't think the comparison with the domestic law in this sense, comparing are you for or against hate crimes and so on, is not so relevant.
But it does matter. But it does matter because it does matter for this reason. Because if the international legal order puts the crime into the box called genocide, it says that the targeting is of the group. If it puts it into the crime of crimes against humanity, it says that it's not. And that, I mean, what we've heard around, that has consequences.
No, definitely. I'm aware of the international legal framework, definitely. But I'm saying, I mean, yes, I do think crimes against humanity should be the sole crimes. I mean, there shouldn't be. I don't think there should be genocide in this sense, because crimes against humanity is enough as long as the crimes are politically motivated, and it's always against the group, no matter how. I mean, whether you narrow the definition of a group or you expand it, yeah, it doesn't really matter. You're using force that's politically motivated to kill persons.
Ask me a quick question, because there's another chap over there. Okay, but you're coming down against the Genocide Convention because either everything is a genocide or nothing is a genocide. Is another way of dealing with it. Okay. Yeah.
You touched on this in your comment about crimes against humanity plus, or maybe it would come into account in sentencing. But I was trying to think of this counterfactual in the historical sense that there's no Lemkin, there's no 1948 convention. It seems to me that you would still get some linguistic distinction between everyday crimes against humanity to the extent they occur and things that look like the Holocaust. And that the historical pull of the Holocaust would still create some term, some concept that would be a trigger for greater international attention, and that even if we didn't have the term genocide, we would still get this hierarchy of things that look like the Holocaust or Rwanda and crimes against humanity, and we would still have all these problems of a group wanting to be associated with whatever term we collectively associate with large-scale crimes that use the coercive power of the state against a group. So I don't think, to your final point of what has genocide done more harm than good, I think maybe that distinction would have been inevitable anyway, even if we called it something else, maybe it had less of a legal basis and didn't have a convention. I still think courts and capitals would have been fighting over this distinction between things that look like the Holocaust.
I'm sure it's right that if we just had one crime, let's just assume it was crimes against humanity, or call it international crime, or whatever we want to call it, a hierarchy of horror would emerge. But the point that I'm making is that the way in which the law has created a range of distinct crimes has tended to reinforce that sense of hierarchy, and has done so even within the context of geographically defined communities. So if we go back to the Yugoslav situation, the fact that the destruction of a village on one side of the border is called a genocide, but on the other side of the border is only called a crime against humanity, has had very nefarious consequences. It has enshrined feelings of unhappiness, and it will tend to perpetuate the ill feelings rather than assist in addressing them. And so the point that I'm making is not that one should consider, how one would do away with a hierarchy of horrors generally, but how we avoid the design of a legal order which makes greater hierarchization possible or even likely. And I think that's what we've done. And I think it's extremely, not only unfortunate, but it's extremely destructive. I mean, you can have this conversation on a micro level. There have been a couple of articles written by former prosecutors at the ICTY describing the pressures they are subjected to internally to characterize a crime as X, Y, or Z, because of all the political consequences it will have of so characterizing or not characterizing. And you've described, I've not been involved and not thought about the Cambodian situation, but I can immediately see, by calling it a genocide in relation to some groups, the other groups become alienated, become marginalized, And that sets in stone a privilege that is perpetuated. These things were never thought through when these crimes were designed. And I think that's the simple point that I'm making. It's by enshrining them in the law, you create a different context and consequence for the direction things will take in the future. And I think informal labels have different consequences from formal labels, because formal labels have consequences that informal labels don't have. Thank you very much for your excellent questions.
So,
really terrific.
You already applauded. I'm going to make people applaud again because I think this was a riveting, thought-provoking discussion, and it will obviously foster many ongoing conversations about these issues, which is exactly what we want to have in the law school. So really, thank you.
Thank you for asking.
Thank you so much. And 1 hour off a plane from London.
Thank you.